Welcome to Retirement Unlocked with Larry Heller. Your life, your way, unlimited possibilities. Join us as we explore how tailored financial planning and investments can help you navigate life transitions with confidence. Let's dive into this week's episode.
And welcome back to Retirement Unlocked with your host, Larry Heller. Joining Larry today is Dom Parillo, attorney, certified financial planner, and director of wealth transfer at Savant Wealth Management in our Manassas, Virginia office. Estate planning is about much more than simply having a will or a trust in place. An effective plan requires thoughtful implementation, regular updates, and careful decisions that can help you protect your legacy and make things easier for the people that you leave behind. In today's episode, Larry and Dom discuss some of the most common estate planning mistakes, why estate taxes may still be a concern despite today's historically high federal exemption, what to consider when selecting the right trustee, and strategies that parents can use to help protect the assets they leave to the next generation. Larry, it is good to see you, my friend.
Great to see you, Bill. Dom?
I'm excited here. You've got a guest from Savant, which is great. We've been talking about Savant for a while now on the podcast. It's good to see somebody from Savant join you.
Yeah. So, Dom, you're our first guest from Savant. So welcome. Excited about talking about today's topic. We should have some interesting tidbits for our listeners out there. So welcome.
Well, thanks for having me. I'm honored to join you in our inaugural Savant guest podcast, Larry. We obviously a big fan of yours as well. Excited to share some wisdom with our listeners.
Yeah. So we've both kind of been around a little bit here to see some of the pitfalls. You maybe more than me because you do this every day. But in my years of experience, I've seen some of the things that we may talk about today. So I thought it would be great for our audience for us to tell them what we see as some of our pitfalls, and so they can avoid them. So we'll talk about a few. I'm not going to get to every one of them, but let's talk about a few. So, Dom, why don't you kind of start us off with, the first kind of pitfall that you see?
Yeah. And you know what? It's nothing major. Sometimes it's the basics that people overlook. The biggest pitfall is just not even having a formal estate plan, right? A lot of people think that, I don't need a trust or a complicated will, right? I've got beneficiary designations. I don't have, a level of wealth to justify working with an attorney. And really, everybody can benefit from an estate plan, even a really basic set of documents. I think that a lot of people overlook incapacity planning, Larry, which, in our line of work is critically important when you work with, elderly individuals and families. Many people, when they think about estate planning, they say, well, boy, if I die, what happens to my wealth? Dollars and cents, how do things get distributed? But incapacity planning, huge pitfall. For power of attorney, for property and healthcare are two documents that people can put in place to allow them to nominate agents who can act on their behalf to make financial decisions and healthcare decisions. In absence of those basic documents, if you become incapacitated, a court actually has to appoint a guardian or conservator over you. It's an embarrassing, a time-consuming process, really should be avoided. So even if you don't think you have the level of wealth that justifies formal documents, like you really want to have those core documents in place, basic power of attorney, basic last will, trusts for probate avoidance. You've probably seen this come up where people are surprised and there's some unexpected health emergency or something, and then they have to deal with it later.
Yeah. So, I haven't really seen that, but I've seen one thing that I want to avoid again in my lifetime. It's kind of the same thing, a simple thing, but a couple that had children and had no wills. And unfortunately, they were killed in a car accident, and both the grandparents were fighting to become guardians of the children. So, and that went to court over that. So, which is really sad to see. So you're right. Some of the basic, simple things that you need.
Yeah.
on the flip side, I've also seen people, sophisticated attorneys out there, very, very successful, who for whatever reason don't go ahead and put their documents in place, from wills to simple documents, even late in life. And that's one of the things that, I do, is try to get them to, to get down and to get these documents in place.
Yeah, it's the shoemaker's children syndrome. Right. That's often important, is that people don't understand the risks and the danger and the pitfall. It's hard to contemplate your own death. And that's the whole point of having an estate plan, is that life is uncertain. I guess one of the only certainties is that you don't get out alive, right? That
Yep.
and paying taxes. But another pitfall, you're talking about some common things that we identify when we're working with families, is you've gotten your estate planning documents in place. They're good. They meet the needs of your family for the time being, but implementation is a big miss. And what I mean by that is there's misconceptions when you actually put your written estate planning documents in place. Let's say you have a revocable living trust. A revocable living trust is a legal document. It works somewhat similar to a will, but in essence, this revocable living trust can allow you to avoid probate when you pass away, when there's assets titled to the trust. Probate's the court supervised process of proving someone's will who's passed away, noticing their beneficiaries, their creditors. It's a formal process, and it can add expense, time, delay, attorney's fees. So revocable living trusts are really popular probate avoidance vehicles, and there's some other benefits. But you got your trust in place, and then you don't title your assets to your trust, and now you have probate. I mean, you go from like an A- or A level estate plan down to a C+ plan in execution. I mean, we encounter this pretty regularly, right? You think, oh, I've got my plan in place, it covers everything, I don't have to do anything. It's just simply not true.
Yeah, no, it reminds me, we have at that time, a potential client who became a client, who came in, and we started to ask those questions. We don't need to talk about that. Let's just talk about the investment stuff. And I pressed him on it. We ended up looking at the documents, and sure enough, he had a revocable trust, and he was real proud that he went to this high-powered attorney, did all this trust. And I basically said to him, after looking all the title of all the assets, do you realize nothing's going through that trust? Because none of the assets were retitled. I think you could see his head explode.
Oh, yeah.
That the attorney never, told him that he had to go back to his advisor and retitle all the assets into his name. So so that's definitely a common pitfall that I have definitely seen.
Yeah, and especially when you're dealing with, let's say you have a married couple, surviving spouse, there's no reason there should be any probate procedure needed. When you're dealing with a survivor. I know things do happen. People have complicated balance sheets. They have complicated lives. So, it's when you get your documents in place, you gotta do your net worth statement. You gotta really verify title. It helps you avoid surprises, headaches later on that are just really, really annoyances. Even if the money does end up going to the right people at the end of the day, just you want to streamline things if you can. Another misconception, Larry, is beneficiary designations.
Mm-hmm.
It's you had a good example when you sit down with somebody and it's sort of like this aha, or enlightening moment. But a lot of people don't realize that beneficiary designations actually trump the written terms of your documents, right? That it's an independent transfer outside of your legal documents. A beneficiary designation applies to an asset like an IRA or individual retirement account, a 401k with your employer, life insurance policies. And in essence, whatever name you write in that beneficiary form, that's the person that receives that account or that asset when you pass away, even if that's not what your will and trust says. So a lot of times, outside of just neglecting to title assets properly, there's also an oversight in reviewing those beneficiary designations, making updates, aligning the beneficiary designations with the person's overall estate plan.
Yeah, let's go back to something. You said that beneficiaries trump wills, and I think there's even one other thing that comes into play there that also trumps wills sometimes, and clients don't really understand that. They think they get their will. They think everything, including their IRAs and insurance, goes through their wills, but they also don't realize that account titling can trump a will, correct? So why don't you talk about that for a
Oh,
second?
that's right. That's another, when you think about how assets pass by beneficiary designation, right? They can pass through your estate plan when you pass away, if it's in your name individually, right? Part of your estate or titled to a trust, like we spoke about. But joint assets, a lot of people forget that if you own an asset with another person, bank account is a big example, or a primary residence. Let's say you're married. When one owner dies, the title automatically transfers to the surviving owner by right of survivorship, operation of law. And again, that happens independently just because of titling outside of your estate plan. So,
Right. And talking of title, because I always have these conversations with people who have like, oh, I don't need that. I have a POD account, and try to explain, if there's a minor child, first of all, some of the old PODs, you can't put what's called per stirpes in it. So, so people have these things, well, I don't need the wells because I have everything as a POD account. So another pitfall that, is kind of a simple thing that can trip people up.
Yeah. And you know what? A POD, a simple transfer beneficiary structure, that might work in a lot of situations, but where there's a huge fail is for contingency planning. Like what if that person you named passes away before you? You mentioned per stirpes. That's a Latin term that means by the roots. That means that named person's descendants receive that asset if they predecease you. Where it gets really complicated is when you're working with blended families, right? And you're bringing two households together, and you might want the spouse to have benefit of the assets, but if that spouse passes away or at that spouse's death, you want the remainder to go to your own biological children. You can't do that with plain old beneficiary designations or POD instructions. You really have to address those issues, those contingencies in your own written estate plan, and really coordinate all the assets. Retitle, update beneficiary designations. There's a lot of pieces to the puzzle there.
Yeah, absolutely. You just kind of jiggered my memory also for another pitfall that we saw, that talk about blended families, and we always ask to make sure we see who the beneficiaries are on all their accounts and out there, and all the insurance policies in there. And so I recall we did this, and we had the meeting with them, and the ex-wife was still named the beneficiary on one of the accounts.
Yeah.
So so it does happen. So it's real important that you check all that, or a missing child sometimes.
Right.
So we've seen it all. So why don't you talk about some of the other kind of, we talk about, those are kind of the basics that could really trip people up and cause a lot of headaches. But why don't we kind of delve in some of the financial things that could trip people up, or the pitfalls of estate taxes?
Yeah. And, the estate tax environment, I would say it's from a modern standpoint in the last 15 years. There's been tremendous changes. If you think back to the late 90s, early 2000s, we had a $600,000 per person federal estate tax exemption. It seems hard to believe. In the beginning of the 2000s, that exemption was slowly moved up, to $1 million, then $2 million. We were on a path to repeal in 2010, and then we had a $5 million per person estate tax exemption. Fast forward to 2026. As part of the One Big Beautiful Bill Act that became effective earlier this year, we have a $15 million per person estate tax exemption. So, not a lot of families, when you think about normal Americans, have federal estate tax problems, and they might say, well, great, I don't have to worry about it. Why are we even talking about this topic? A pitfall is that's just one part of the tax system, the federal estate tax system. The state that you live in, can also have independent estate or transfer or even inheritance taxes that apply. Larry, you work with a lot of clients in New York, where you're based. New York has a $7.35 million per person estate tax exemption. And one unique thing about New York, and this is true of some other states too, is that there's no portability of that election. And what the heck does that mean, portability? Well, when you think about the federal system, if you pass away and you don't use up your $15 million exemption, your surviving spouse, if you're married, can actually take your unused exemption, right, port it over to you via a portability election and add it to his or her own estate tax exemption number at the second death. So there's no
So
loss.
federally, you're basically getting a $30 million.
Federally, you get 30, right, if you're married. Now states like New York, for example, there's a $7.35 million exemption, but there's no portability. So you have to do special planning in your written estate documents, your trust, or even your will, to capture that exemption or that credit at the first death.
Right.
That gets missed. And again,
So just to clarify,
Yeah.
with federal, you don't have to worry about putting assets in each one of the spouse's name.
Right.
But in New York, you really want to have the 7.35 at least in each one of those names, correct?
Yeah, you want to make sure you're utilizing as much of that exemption at the first death as you possibly can. So that's exactly what you're saying. And what we find is that, well, wealth is often unbalanced, right? Even with married couples. You have one high income earning spouse that tends to have and accumulate assets from, in a 401k plan, employer stock options plan. Maybe there's some joint assets, but again, joint assets pass to that surviving spouse. They bypass the written terms of the trust, and we're that credit shelter trust, or that special provision to make utilization of that New York exemption is lost. If that first to die spouse doesn't have enough assets in their name or their trust to utilize it. So a lot of times, it's the structure of assets, ownership, title that really influences whether there's going to be an estate tax at the second death. Very, very common. We see this all the time.
Yeah. And New York has another surprise for you, the cliff tax.
The cliff. Let's talk about the cliff a little bit. And this is pretty unique to New York, but like I mentioned before, there's a $7.35 million basic threshold. Now, when your estate exceeds the $7.35 million threshold by more than 5%, so you get to about $7.7 million in estate value, you lose the benefit of the entire New York exemption. Kind of wild. So even if you have, as a couple, you're just above that, you have to really be careful, because you might think, oh, we don't have to worry about estate tax. We're less than 15 million. Yeah, but again, if you inadvertently cause that survivor to be over, the 7.35 million, and you get to 7.7, it's a lot of tax that you could have otherwise avoided.
Yeah, it could be a significant amount of taxes.
Yeah.
We were talking earlier today that New York's losing a lot of residents to the no estate tax states such as Florida. So now the word on the street is they're thinking about some type of exit tax when you leave New York. So that'll be interesting.
Yeah.
If that ever comes. Hopefully not, but
yeah. I mean, California had a similar proposal recently. And some of our listeners, they might not be in New York. It's good to understand the system in the state that you live in. For an extreme example, Oregon State has a $1 million estate tax exemption per person, very, very low, no portability. Where I'm from, originally Illinois, I'm born and raised there, we have a $4 million per person state estate tax exemption, no portability again. So very, very unique. It's good to understand your particular circumstances, right? Your level of wealth. What can you do to minimize estate tax exposure?
Right. So the pitfalls, and want to worry about the estate tax, not just federally, but make sure that you have the estate tax kind of minimized where you can.
Exactly.
So let's just some of the other kind of pitfalls that you've seen, Dom.
Yeah. Another one is just outgrowing the terms of your estate plan. So estate planning is a little bit daunting, right? You have to make these decisions, think about the future, contemplate your death. You got to work with an attorney. You're paying legal fees. it's like a triumph when you get it done, and you just want to put that, your book that you get, your binder with your documents up on the shelf and just sort of forget about it, right? Oof.
Mm-hmm.
But what we find is that people's families change over time. Their assets grow, right? There's changes in values. There's marriages. There's deaths, and you might have had an estate plan that made sense at the time you wrote it, but now your children are much older. Your net worth has doubled or tripled from when you first started working, right, with young family, and you may have outgrown some of the provisions. Very commonly, it would be the tax issue we just spoke about, state estate tax. But I guess another big one is protections for children. God forbid, you and your spouse, or maybe just you, you pass away. Are your documents set up to provide a windfall inheritance to your children who might be young, right? Might not be mature enough to actually manage these assets, and steward them, right? So what families can do, they can create continuing sub-trusts, we'll call them, in their estate planning documents. A testamentary trust is another term where when you're gone, a trustee can continue managing these assets for your loved ones, right? If you have young children, nieces and nephews, because it could be disastrous, Larry.
Mm-hmm.
If a young person, 21 years old, 25, receives a $2 or $3 million inheritance unencumbered. I mean, it can really cause a lot of problems.
Yeah, and when we get asked, sometimes too, is like, because they realize they're leaving a lot of money to their children, but what happens if my child gets divorced, or what happens if there are creditors after them? So, those are some of the other questions that we see occasionally.
Yeah, those issues can be addressed with the trust structure. Again, the idea is that there's a trustee who manages the assets for the beneficiary. The beneficiary is the person who can receive distributions from the trust, but there's independent oversight by this trustee that actually has to approve the distributions before they go out to that young beneficiary. So that can help protect the beneficiary from themselves, right? But a lot of times, families instill good values in their children, and they're mature, but they want to protect those children from outsiders, right? Creditors, known and unknown, preserve assets from divorce. So, and the devil's in the details. Every state is different
Mm-hmm.
as to how the law is applied. But generally, you spoke about divorce. When you inherit an asset from a parent, for example, even if you're married, if you keep that asset separate, let's just say it's in a trust account and it's not commingled with joint or marital funds, it can stay separate. And if there
Mm-hmm.
is, God forbid, a divorce, it's not included in that marital estate for asset division. So those trust structures are a way to keep the assets
Right.
separate, and mom and dad do that in their estate plan.
Right. And you mentioned, we started talking about trustees before, and some of the pitfalls that we see. Even you've done that, you've done the wills, you've done everything, and you think everything's the same, but some of the trustees may need to be updated. As you said, people get older, people pass away, and
Right.
not seeing, going through, oh, Uncle George is still the second trustee. Well, he's 86 in a nursing home. I think it may be time to change that. So that's another pitfall, is not having the appropriate trust, or even backup trustees.
Yeah. Yeah, I see that quite often, as there's a deficiency in the fiduciary appointments in the documents, right? That's a fancy term for trustee in a trust. And when people are putting their documents together originally, they don't know, right?
Hmm.
Who should be the trustee in the future. They're sort of planning for the right now, like the next 3 years. So oftentimes there is no successor named after husband and wife, because they didn't know who would be in a good position. Or the person that they named has passed away, or they're in advanced age and they're not in a place to actually serve if needed. So this is another this trustee selection question. I mean, this honestly is one of the major roadblocks for people actually getting their documents done or making updates. And I think trustee selection is critical importance, right? Because this trustee is going to have an ongoing relationship with your loved ones, managing these funds for their benefit for as long as the trust continues, right? That could be until the beneficiary dies in the future, right? Their entire lifetime, or it could be a number of years. It just depends on what the trust says.
Yeah. So this has been great, Dom, with some of the common pitfalls that we've seen in estate planning and wealth transfer. So hopefully you've learned a little bit to avoid some of these pitfalls out there. And if you're kind of thinking about them, maybe it's a good time to review your estate plan. Any final words, Dom?
No, there's a lot here, but don't forget the basics, right? Just brush off or dust off, as I say, those documents, understand what you put in place, think about your values, think about your assets, think about your children or their loved ones. It'll help you really determine whether you need to make updates or not. And just know that, estate planning doesn't end. It's an ongoing process for the rest of your life.
Absolutely. Dom, thanks so much. This has been terrific. Hope everyone out there enjoyed this episode.
Well, I know I enjoy listening to you guys. So Dom, thanks for me and for sharing your expertise with us on Retirement Unlocked.
Thanks for having me. It's been my pleasure.
It's been great. And listeners, if you learned about estate planning and what things to look out for, share this episode with someone you may think could benefit from this information. You want to make sure your estate plan is on the right track? Check the episode description for a link to Heller Wealth Management, where you will find additional resources and the option to schedule a complimentary 20-minute call with our team. We'll catch you next time on Retirement Unlocked. And reminder, Health Wealth Management is now a part of Savant Wealth Management, right?
Yep.
All right. Well, I can put that in there right now just so that it's on there so we can edit it in.
Yep.
All right. And for those listeners who don't know and aren't aware, Heller Wealth Management is now a proud member of Savant Wealth Management.